submit that Mr. Chakraborty would submit that this is this memo has been issued with the concurrence of the council.
Yes.
Correct. So
that would be
I've seen that last line. So that is your contention. And
that would be evident from page
last line, yes, the authorized one we have seen.
Not only that, Lordship kindly sees 156, 157 and 158.
Achha, just a minute. But let me record that.
এটা সাপোর্টে মিনিটসটা দেখাচ্ছি।
Yes, yes. So sorry, Mr. Chakraborty, we speech page 15.
এটা হবে না, তার কারণ এটা হচ্ছে 24 এপ্রিল। No, my lord, I stand corrected. The date shows, my lord, it is not, my lord, as your lordship was indicating, my lord, June 14, 2017's concurrence, it doesn't appear to be so.
It's
Because it is
24,
signed on-
different date. So,
No,
no, you are my officer. I accept your contention. And I have all confidence in you, Mr. Chakraborty. So therefore, very well. So that was your contention.
Now, my lord, I'll just request your lordship, my lord, kindly have a look to, my lord, page 394 of the compilation. Because his representation, your lordship has seen. Now, my lord, I'll try to show your lordship that all his grievances, at every stages, he was given an opportunity of hearing.
Sorry, which page?
Page 394. Your lordship's, my lord, first query was whether the report of the fact-finding committee was handed over to him or not. My lord, this is,
It
my
was
lord,
handed over.
it was handed over.
What was handed over? That is an admitted position.
Yes.
Because he responded to that.
Yes. My lord, 394 is the, my lord, enclosing letter, and my lord, 392 and 393 is, my lord, the service proof. My lord, I'll just request you,
Take
Lord.
your seat. Are you in a hurry?
No, no, no. But I'm just taking the note from the document. Compilation, that compilation has not been served upon us. Only I am taking the point from that.
It is all these documents
No,
are
no,
with you.
I have, my lord, only after perusing the
There is
document,
no-
I am just taking.
Forget compilation. I will not rely on the compilation. These are all with you.
Yes, my
All
lord.
served, Lordship.
Yes.
If I
What?
take any decision against you on by relying on any document from the compilation which has not been served on you, I have to make it available to you. So therefore, be rest assured. Take your seat.
My lord, I'm just perusing the document and taking the note.
But after all, this is a disciplinary proceedings inquiry.
Yes.
This we are doing in a read proceedings. Actually, what we are doing, a suit has been tried. Now, although this is not an appeal, but I have to find out, examine everything,
Yes.
whatever is shown to me. I cannot just reject it by saying either on your part or allow it. Because that will not be rendering justice to the parties, both the parties. Both the parties are entitled. Because this is the last. After all, after this, I do not know in on the next tier of hearing whether these matters will be looked into in this fashion or not. Because it can't expect. So since Mr. Chakraborty is there, you are there, I got the opportunity, all the matters are there. I'm going through the papers.
Then, my lord, I just request your Lordship.
He is required to show not that a different finding could have been reached. He is not required to show that. He is required to show, let us understand the test. A, that an inquiry had been conducted or not. B, whether the delinquent had been given due opportunity of representation, which means and includes service of the show cause with the detailed charges identifiable and the charges are not vague. All documents, relied on documents, whatever is there, based on which a decision is proposed to be taken, made over to you. Any witnesses are there, statements which are relied on, permitted to be cross-examined by you. And after that, after hearing your stand, to take a decision which is more or less plausible. But a different view, court comes to a finding a different view is permissible, court will not alter the view which is there. Correct?
Yes.
The next stage is whether you had been given an opportunity to make a representation to the show cause, ECIL Karunakaran.
Yes.
But provided if you have not participated, then it will be ideal formality, so not necessary. Whether you have responded to, whether your response has been taken into consideration by the disciplinary authority, such opportunity may not be necessary if the disciplinary authority himself is the inquiring officer. But if there is a distinction between the disciplinary authority and the inquiry officer, in such case, the inquiry officer, the disciplinary authority is required to give you opportunity. For instance, the disciplinary authority, the inquiry officer has decided 5 charges, 2 in favor, 2 against. The disciplinary authority considers no, on the basis of the evidence on record, all the 5 charges have been proved. So he has to give a tentative finding to you for you to respond to that without taking any decision. This is what the court will see.
Yes.
My endeavor is only to see this much and to find out that the judgment delivered, or not the judgment, the findings of the inquiry officer are based on some evidence which will, on which this conclusion can be arrived at. I am not here to examine whether the evidence was totally sufficient or not, whether something was lacking or not here to examine. But if I find that it is based on no evidence, then it tilts again. So it's like a pendulum, it will shift. So Mr. Chakraborty doesn't have much to show, but he is making a very serious endeavor before this court.
Milord, only one, Milord, Milord, humble submission. Milord, subject to your lordship's kind
Yes, this is what is all you are required to show, Mr.
Absolutely,
Chakraborty.
Milord. But Milord, only with a one caveat. Milord, provided, Milord, the charged officer, Milord, challenges the inquiry report. As your lordship is, Milord, I bow down to your lordship. Milord, the inquiry report has
I will
not
take
been
into
challenged.
consideration. You have made that point. I'll consider that.
Yes.
I'll consider that. Any
He
judgment
allows
you
it
want
to-
to support that also, you will place it before me.
Yes, Milord.
That if he has what is a challenge to an inquiry? You see, I'm a very expressive judge.
Yes,
Makes
Milord,
it-
that is, Milord.
No, because
Milord,
because I discuss it, so it will be easier.
otherwise,
What
Milord,
is
we would
going
not
through
be
my
able
mind
to,
is-
Milord,
because
answer your
otherwise
lordship's
it will
query.
be never-ending process. But if I discuss it too much, then you will be plugging the gaps. For plugging gaps, you will be arguing the matter more and more. It's also two ways. Both it cuts two ways. Anyway, be that as it may. If you say that if he has to charge officer the delinquent, the delinquent had in fact challenged the inquiry report. Now, how an inquiry report is challenged? Ordinarily, an inquiry report is challenged by filing a response to the same. Ordinarily, I say.
Yes, Milord. Milord, I completely agree. But that stage is also over.
So
When
therefore,
his
has he not
representation
filed
is
it?
disposed
So
of.
to the extent he has challenged it in the reply, that is only sustained, not beyond that. That is why I wanted to see the reply.
Thereafter, Milord, the reply has not been challenged by him. So, Milord, he
reply?
has, Milord, the disposal. I mean, Milord, the disposal order.
That is different. Anyway, you proceed on that. Proceed on.
Milord, now, Lordship may kindly have a look to page.
Now, yes, sorry. What do you wanted to show me? What did you want to show me?
Milord, page 349 and 350 of the compilation, just to show and answer your Lordship's query.
What is 359? Just tell him, otherwise he will
Yes,
not.
Milord, the article of charges, statement of imputation of misconduct or misbehavior, list of documents, list of witness.
This was all given.
Served.
This was all. There is no dispute with regard to this.
Milord,
I
I'm
will-
just indicating, Milord.
I will accept your contention on this, Mr. Chakraborty.
Yes, Milord. Milord, I have prepared a. Yes. Of witnesses. Article of charge, statement of imputation, list of documents, list of witnesses. 30th March 2015.
ওকে বলবে এটাকে ডিস্ট্রয় করে দিতে। Yes.
Lord, then Lordship may kindly consider, Lord, the inquiry officer's report was also served.
All these parts have been
Now, my lord,
complied with.
I'll
I do not
since
say
your
for
lordship,
a moment that you did not comply
yes,
with
my lord,
this.
your lordship posted me a query, my lord, with regard to my lord the challenge he has thrown, my lord, against the inquiry officer's report. My lord, at what stage he can, my lord, I'm stretching my lord further. At what stage he can, my lord, challenge an inquiry officer's report on technical grounds? My lord, Supreme Court has clarified that he has to, my lord, made the challenge in during the pendency of the inquiry, not after that.
Look,
Here, my lord, the inquiry report, my lord, was prepared
no
before that.
report, you see, Mr. Chakraborty, he cannot challenge the report during course of inquiry because the report is not in existence during course of
No, my lord, the procedural.
Correct.
Procedural part, my lord, Supreme Court has clarified if any, my lord, irregularity is happening my lord, he has to make the challenge in during the proceedings is pending, during the pendency of the proceeding, not after that.
On question of violation of principles of natural justice.
Yes, my lord, that also I'll be coming. I'll show my lord the inquiry
Because
report.
why that is so? Because the question of waiver would be there. Waiver would be there.
My lord,
Waiver.
that is the
Whether he has
exact
waived his right, knowing
it is
fully well.
State Bank of Patiala's case, my lord. If your lordship can
Yes, yes. They are very
that
clear
can be
on that.
taken and answered by the Supreme Court.
Give me that judgment. There is one. I'll point out to you from that judgment. Very interesting
My
paragraph.
lord, I
I
already
have handed over. Yes.
handed over, my lord. If I'm not wrong, then my lord,
আছে দাও তো না না আছে আছে এগুলো নিও না ডবল ডবল নিও না ওখানে নেই এখানে আছে আছে নাও
1996 volume 3 SCC.
ইয়েস
The lordship got, my lord. My lord, with regard to this submission, my lord, I'll
which
be
paragraphs you want to place
Lord,
first
earlier, my lord, I relied on paragraph 33, but now, my lord, I'll be relying on paragraph 33, 34,
you become
35.
wiser now
The 34, 35,
yes yes
9, 11, and 32. Lordship kindly takes note of this. At what stage?
the petitioner will say that with a smile on your face and a sugar knife you're attempting to kill the petitioner paragraph
My lord, paragraph 34, 35, your lordship kindly
34
sees.
35 yes
Then I'll take your lordship to, my lord, the previous paragraphs also.
34 to read 34 Mr. Chakraborty read 33
33 already placed, that's why.
yes
33,
no
my
to
lord,
read 34 you have to read 33
I bow down, my lord.
that it is
33, my lord, may I just
if
read,
it
my
is
lord?
this is not this cannot be read in isolation
Not in isolation. Not
yes
in isolation. 33, my lord, I already placed. I
yes yes
just want
now having regard to that place 34
yes.
now in which of the above
Now, in which of the above principles does the violation of subclause 3 concerned herein fall? In our opinion, it falls under principles number 3 and 4A mentioned above. Though the copies of the statements of two witnesses, so and so, were not furnished, the respondent was permitted to peruse them and take notes therefrom more than 3 days prior to their examination. Of their two witnesses, so and so was not examined and only so and so was examined. The respondent did not raise any objection during the inquiry that the non-furnishing of the copies of the statements is disabling him or has disabled him, as the case may be, from effectively cross-examining the witnesses or defend himself. The trial court has not found that any prejudice has resulted from the said violation. The appellate court has no doubt said that it has prejudiced the respondent's case, but except merely mentioning the same, it has not specified in what manner
and
in
how it has
what
been
sense.
prejudiced so
Yes.
naturally
Now,
prejudice
my lord,
factor
two things. First of all, my lord, he has to raise an objection in pendency of, my lord, the inquiry. Second thing, my lord, taking the worst case, what prejudice has been caused, my lord, he has to show that.
always Mr. Chakraborty always that is always
Now, my lord,
Yes.
I'll just take your lordship to, my lord, 295 of the compilation. My lord, the inquiry report starts from 289.
just a minute
Yes. Lordship, may kindly have a look to page 289 first. Lord.
29
289. Lord, this is the inquiry report, Lord. Your Lordship will get, my lord, the brief history of the case. Then, my lord, I'll just keep over to, my lord, the bottom of the page. Inquiry officer so and so was appointed. Your Lordship got, my lord, page 289. যে contest করতে চাই না, defense. Lord, every stages, my lord, he has been given opportunity that is recorded by the learned inquiry officer. If your lordship kindly skip over to page 295. After the list of witnesses, my lord, lordship kindly sees, my lord, what happened. At every stage, my lord, he came to, my lord, knock the door of this Honorable High Court. But he couldn't challenge, my lord, the inquiry report. Lordship kindly sees at every stage, my lord, right from the beginning of show cause, suspension, my lord, at every stage he came. Even, my lord, he challenged, my lord, the constitution of the, my lord, appellate authority. But he, my lord, couldn't challenge, my lord, the inquiry report before this Honorable Court.
Before this court, yours.
Yes, my lord, he has a
Challenge to the inquiry report is there by way of his challenge can be only limited to the challenge made by him in his reply. He
Grateful.
cannot enlarge that
Grateful.
challenge.
But, my lord, that has been
Whatever
addressed.
is there is there. I will not look one line further than that.
Yes.
Unless, of course, glaring inconsistency is shown for which the court will not keep its eyes shut. That is something. But he has not been able to. I'll be very clear. He has not been able to show that. His points are different.
Yes.
And you said that, although I'll consider that, what submissions you had made, that you had said that he had merely said simply because Xerox of those documents have been relied on.
Technical, my lord, grounds.
No, please understand, not technical grounds. What is the charge? Serious charge. Had it been a criminal case, the onus of proof would have been different.
Yes.
But it is only on the basis of preponderance of probabilities that this can be proved. But notwithstanding that, what have been relied on? Copies of email communications without the recipient coming forward to establish how a document is proved. You tell me, Mr. Chakraborty, later. You have done original proceedings.
The person
How the recipient
has
has
to come and
forward,
depose.
or
Yes.
the tenderer has to come and say, this is a photocopy. Tenderer. Two persons can prove the document. Third party proving such a document by downloading on an electronic mail from that setup are different issues for which different set of procedures have been laid down.
My lord, two things, my lord. Whether, my lord, this, my lord, irregularities, so-called
Well, I'll give
irregularities.
you a little more time to conclude. Today it is
My lord.
a little more time to conclude because next week only.
Well, I'll finish.
I'll fix a time.
Yes. 10:30. Because every
Yes, well,
Friday
what is your advocate and your court suggesting? Junior suggesting.
She is suggesting, my lord, to, my lord, inquire from your lordship, my lord, what are the points, my lord, your lordships, my lord.
I have clarified. So I don't
Any
hold
other
back the
points, my
point.
lord,
I
I'll
give
just
you
take
the
your
opportunity to explain.
Lord.
So that, yes, Mr. Chakraborty is always so prepared in matters. Wonderful advocate.
My lord, I have a bad case, I know, my lord.
That is a different issue. Here, how can you say bad or good? Have you decided this? Leave it to the judge to decide ultimately.
My lord, when, my lord, the opposite party, my lord, is arguing, my lord, in a fashion, my lord, which the petitioner has not argued. He has to give reply. That means he has a bad case, my lord, subject to correction.
I am also learning from him.
Well, he has not, my lord, subject to correction, my lord, the learned advocate appearing for the petitioner never, my lord, in his course of argument, never took these points. My lord. This is only your lordship's query, my lord. I'm trying to.
No, these are
these are the relevant,
points
my lord.
in our disciplinary proceedings which in
No, these are the
normal
fundamentals.
course will arise.
My lord.
And you have done so many matters, Mr. Chakraborty. You
This is my core point, my lord.
are
Because
not
the
only equipped, you are aware of.
principal justice is, my lord, is there. Your lordship rightly pointed out.
চলো বলছি এসো এটাকে wait, I'll direct it.
It's fine.
সামনের সপ্তাহে কি আছে? সামনের সপ্তাহে কি আছে? ডায়েরিটা বের করো না, প্রসেনজিৎ কোথায়? Here only if I find any difficulty, I will direct it to, not necessary. Since you
Because
have now copied them, these are all entirely here.
your lordship passed a formal order, my lord.
Yeah,
That's
I
why if
know.
your lordship kindly passes.
No, you need not bring it because I'll be taking up there if required. Because if required on the last date, then I'll call for it again. I'm not this so therefore once I return it, I cannot call for.
They are
Court
coming
cannot-
far from sector 5, my lord.
He need not bring it. Rest assured, he need not bring it. Only the matter will be taken up. If necessary, I'll call for it. But once I dispense with, then it's ordinarily court should not thereafter call for it. So he need not bring it on the next occasion. দেখো লেখো কবে আছে? আমি সপ্তাহে বেশি আছে।
4th of July.
4th of July at 12:30. At 12:30 তো হবে না, পৌনে একটা বেজে যাবে। At 12:15. 15 minutes there and 45 minutes on the other side. So you'll get an hour. সব কাগজ তুলে দিয়েছো নেই করে? দুটোর সময় কি কি মামলা আছে?
My lord has heard the matter from time to time. It is not that issue is not unknown to your lordship. The petitioners before your lordship are the wards of the persons who died in harness. They were father and one is husband of the petitioner, some of the petitioners. The particulars of their date of death has been given in paragraph 4. Their working has been avowed in paragraph 3. Their father was working, or the person my lord, who was working, his wife is now before your lordship also for compassionate appointment. They applied for compassionate appointment. Interview was held. After interview, my lord, they were selected, their testimonials were tested, and they are in the interview itself, my lord, they did not speak of their employment on compassionate ground in died in harness case. It is a simplicity letter, my lord, which gives rise to an impression that we should be regularized in a regular employment. We are given this particular offer of appointment. But after
I couldn't follow you, sir. Mr. Bhattacharya.
it appears to be that offer of appointment is given to a regular employment as a regular employee.
Which page you are relying on?
Kindly come to page 49.
Yes.
This is an offer. Your prayer for employment in NBSTC on compulsory ground in died in harness case.
Page.
It is a case before your lordship is
Page,
Subhas
page.
Ghosh. Page 49.
No. Tell me the letter. Letter dated 1st October 2008.
1st October.
Page 40. Anyway, 44. Very well. Your request to appear. You are requested to appear on 20th October 2008. That letter.
That letter.
Very well.
That
Same
letter.
letter. Same letter.
Same. কি হলো?
কোনটা? Yes, 6-7 is here.
Lordship is has taken up 6-7.
Why? You want to place any other? Sit down, sir. Kindly.
লাভালাভি করলে হয় না।
Yes, I've seen that letter.
They have been given the offer of interview, appearing before the authority for an interview. What interview has been inserted there in the very first paragraph, second line. Produce necessary testimonials, valid conductor's license in order to support of your qualification, etc. at the time of interview. But we were all treated to be eligible for such appointment on compassionate ground during the interview because we all submitted all our testimonials required for being appointed as a conductor in the said corporation.
Yes.
Now this goes up to page 68, the interview letters. Page 69 is the letter of appointment.
Yes.
That is 2006, not 2008.
10 December 2008.
My lord.
Why you can't read? Your letter is not clear.
With reference to the interview held on December 2008, so and so following hereby appointed the conductor as on contractual basis. Now we have been designated as to be appointed as a contractual contractor at a remuneration of rupees 4,000.
All this you had showed me.
This is a list bunch of persons names are there who have been engaged.
Admitted position.
Admitted position. Now we prayed for that we should be given in the regular establishment appointment on regular basis because the persons who died all are our predecessors were the employees. predecessor's employment was a permanent employment. It is not that the new sanction post is required. These are the all sanction posts. A died, his word has come. B died, his word has come. Therefore, all are sanction posts. My predecessors all were in the sanction vacant post working in the corporation. No question of new sanction do it arise. Therefore, we should be absorbed in those posts on the question of compassionate appointment. Well, a lot of the correspondence were made. Lot of correspondences were made.
No, you are continuing from 2008.
Yes. Now the remuneration has been increased to 14,000 as on today. There was 13,000 and not. It is not at par with the regular employee, although we are in the regular employment in the state, doing the same job as that of a regular employee. There is another limb of the argument. Same job as that of a regular employee, we are doing it, but we are not paid.
This position is all admitted.
All admitted. All admitted.
Up to this stage, everything is admitted.
Up to the
Admitted,
last stage,
Mr. Sen, admitted. Up to this stage, admitted. I've heard him. So you tell me up to which stage is admitted. No, he has argued. He has shown me that appointment was there, letter was there, interview, appointment, engaged, payment is being made, and continuing in service till that admitted. Very well.
now when we pray for an appointment.
Now you place the contested portion. These are all Mr. Bhattacharya.
Contested portion is that they have taken a defense that we have no scheme, we cannot regularize you.
Only this is the contested portion. Whatever you want to show on that contested.
We have
See,
given the affidavit showing that a large number of persons have been given appointment on regular basis who were in the compassionate appointment, and we have been utterly discriminated and adversely. The documents are
So this is contested part. I have asked him to argue the contested part. So you will answer to that. Admitted part unnecessarily he will not. As it is, we are pressed for time. You are pressed for time. The court is pressed for time. Everyone. Mr. Bhattacharya does not find time to come. So let us skip that.
But kindly come to now. Now let us come to the affidavit in reply filed by us.
No. First, show me their defense in the opposition and then come to the reply.
That is the
Although
defense I
Mr.
have
Sen
said
will
in
get
his
an
lordship, there
opportunity.
is no scheme, that is the only defense.
Show me that.
Opposition টা দেখ।
বাবা ভাজা করে ফেলেছো তো তোমরা।
Well, that is a comprehensive affidavit containing affidavit in opposition on behalf of respondent number 1 to 6.
ছাড়ো,
1 and 6.
পরে ঠিক করে দিও, ঠিক করে সাদা কাগজ রাখিয়ে। ছাড়ো। Yes.
Now,
Which paragraph you want to rely your reply?
Page 3 onwards. Paragraph B. Has Lordship got it? Yes.
Scheme.
Regularization individual and economically viable operational expenses, salary and wages, staff and so. Detailed dues arising out of superannuation of the employee, which include a huge number of surplus staff in comparison with the actual need. As a result, that a considerable amount is earmarked for each year budget allocation by the state government to defray the expenses towards the salary and wages, as well as the payment towards the retail benefit of the employees of the Sansu, including the respondent corporation. Though none of the employees of the state transport corporation is undertaking is the employee of the state government. However, fact remains that apart from the above, in order to comply with the terms of a scheme for disbursement of outstanding retail dues of the superannuated employees, recently the state government sanctioned more than 300 crore rupees. It has come to the notice of the government that from time to time, respondent corporation as well as some of the transport corporation upon consideration of the application from the heirs of the deceased employees on human.
So have you been discharged? They cannot continue with you. Have you been discharged?
We have not been discharged. We are continuing.
Still continuing.
Still continuing.
That is their defense. Any judgments you want to show on this?
Before I go to the judgment, my lord, Lordship will kindly come to our reply to this. It has been affirmed on 7th of August 2017.
What you will deny? Whether
I
there
say
is
that
a
a
or
large
not.
number of persons have been given appointment.
That is it. All discrimination. Nothing more than that. You cannot deny whether there is a. You are for? Mr. Sen is appearing for? He changed.
Floating lawyer.
No. Resume castle. All on a sudden from in North Bengal State Transport, you changed your position. Yeah. For the state.
But my name has been recorded.
I see. So we'll cancel it out. Very good.
My lord,
So you want to have a more stronghold with Mr. Nayak. Anyway.
This is our very short and brief submission to your lordship. Lordship, I draw your lordship's attention to certain documents.
You don't leave the court. Be here. It's necessary. You are the contesting party. Very well. Mr. Sen will hold the fort. Correct. Anything else you want to add? Any judgments you want to show?
Like I am showing the documents, man, are showing that a large number of persons have been given
At
compulsory
a
appointment.
particular point of time, if some persons are given, that can not
No,
create any
this
right.
without scheme we cannot do. That does not stand. That defense does not stand.
Say very well. They have taken certain persons. Which page?
Page 30 onwards
Of
my
your-
affidavit in reply.
30 onwards.
Yes.
Of your rejoinder.
To my affidavit in reply. This is from State Transport Corporation, Kuch Bihar. These are the question of scheme does not apply.
Affidavit in reply filed by
Subhas Ghosh, 7th August 2017 affirmed.
কিসের থেকে বেরিয়ে গেছে নারায়ণ স্বরূপেরটা এখানে ঢুকে গেল কি করে করেছো দেখছি পরে ছাড়ো পরে দেখবো ইয়েস পুরো মিলছে না show me judgments you want to rely. Rest is not necessary. What are the judgments you want to rely? Don't multiply. Any judgment on for
These
one.
bunch of documents Lordship will kindly consider.
I will consider it because it's not. It's. I'll get a copy
now,
from Mr. Sen.
now, my lord.
Mr. Sen, you kindly give me an additional copy of yours if you have one.
additional copy
Of this. Oh, Mr. Bhattacharya, you give me an additional copy of the reply. So I'll tally it. Some of the pages have come out. I'll give it back to you. রাখো এখানে। Any judgments you want to rely on?
Latest judgment আছে যেটা আমি এখন দাগ মারলাম।
What is the first judgment you want to rely on?
Well, I take note of the defense, my lord, they have taken.
You will not. Yes. What are the? Tell me the judgments first.
এটা না।
How many judgments? One or two?
One or two.
One, only one?
আমার এই জাজমেন্টটা দে না। এই জাজমেন্ট এখন পড়ছিলাম। Well, I was relying so in 2022 volume 4 SCC 404
Yes, name? Justice Vikramnath judgment.
Malad, this is a judgment of M.R. Shah.
Imar Shah.
With
What is the cost type?
cost title is G. Sadasivam Nair versus Cochin University of Science. Malad, here the issue was, Malad, where a particular benefit was not or should not have been given to a particular class of persons. And if that same benefit is given to one individual, the challenge was made that since it has been given to one individual, relaxing the rules even if there is a rule, you have given relaxation, given the benefit, that benefit cannot be denied to others. The negative argument that was being nowadays very popularly floated to a Lordship's court, that one wrong cannot be perpetuated. If you commit wrong, I cannot be given the benefit. I cannot be compelled to follow giving the same protection to the another citizen.
Which paragraph?
There the court has very, it is a very short judgment. Lordship may kindly take it. From page to paragraph 24 onwards. Paragraph 33 is also vital. Since it has been given relaxation in respect of one person, you should be given the same benefit to them.
Very well.
Malad, the same defense was taken in respect of another matter.
Denying benefit of Rule 25A.
25.
Very well. Any other judgment?
Yes. Malad, Justice Mantha's judgment, Malad, 2018, Volume 2, WBLR, Calcutta. Should I give a book or this will be completed? Just a minute. Page 648. It was a contested matter where the point was taken, Malad, regarding regularization of service of on compulsory ground, Malad, appointment to be regularized or not. That issue has been considered here. That is also, Malad, in West Bengal Essential Commodity Supply Corporation Limited. In that case, Malad, the Honorable Court, Malad, there is a bunch
No,
of
which paragraph you want to rely on here?
page paragraph 29. There are only 3 paragraphs I shall be relying on, 29, 30, 31 of the same. (32) is also the penultimate direction.
But you will not rely Uma Devi. You will rely Uma Devi through this judgment.
Uma Devi has been considered here.
But you will not rely Uma Devi.
Uma Devi has no application in this.
No application.
Because we are the compassionate appointment has been made. We are working for 8 years. Today, my lord, Uma Devi cannot come in my rescue. Uma Devi cannot come in my rescue, my lord, because the government, I am very much, my lord, relying on the discrimination done to us. Scheme part, even if is admitted, the scheme part has been waived and given appointment to a large number of persons. Why don't you regularize me? Against the post in which my parents were, my father was working as in a sanctioned vacant post. And
Yes.
here is a direction mandate was given that give approval to the appointment. Paragraph 32. Joyita Didi.
Any other judgment you wish to rely?
One judgment, I shall be giving Monday to your lordship.
Monday.
Only the judgment. That judgment is known to your lordship.
Yes, Mr. Sen.
Casual workers should be given the same pay as that of a regular employee. Even that is protected to me, my lord.
So you rest your case, if I have understood your arguments correctly, on equal pay for equal work.
One hand, and compassionate appointment on regular basis also in the my principal prayer, my alternative prayer, my lord, equal pay. My principal prayer, my lord, I should be given appointment. Absorb. The judgment of Supreme Court, my lord, Lordship also, my lord, quoted that in courts of argument that why these benefits should be given. I shall be handing over the judgment on. Next. That is a celebrated judgment. Everyone, well, very much knows. Supreme Court has said that
I don't know.
Lordship has indicated me. Won't say this. They contemplated to make a scheme, but they did not do this. In any event, today's position is so. Well, may I take your lordship leave? I conclude it. Great.
This is not a case where prayer is not at all. Kindly come, but I shall not take much time, but kindly come to prayer. First, let us ascertain what are the prayers and so the nature of the petitions. The prayer at page 24. Please.
Yes, yes. Got to.
The first prayer is there. We issue declaring that the petitioners, being the ward of the deceased employees of North Bengal State Transport Corporation, since having fulfilled the criteria for their appointment under the ID scheme. First of all, no scheme, but it said that under scheme, fulfill criteria, they are legally obligated to approve appointment and to regularize their service in regular establishment, and then the same prayer in the prayer B, that again vacant position. So no prayer regarding that, what Maharaj said that just now, that equal pay for equal work. So that model. Now, my lord, kindly, if your lordship, my lord.
So regularization prayer is there.
Regularization prayer is there. Regularization prayer is there. My lord, the three concepts are totally different. Appointment under compulsory ground. Regularization may not be under compulsory, but under in any circumstances, contractual, casual, and then they claim for regularization. A different aspect on compulsory appointment, and another totally different aspect. Again, very good. Not regularized, not appointment under compulsory, but equal pay for equal work. Suppose basic pay or other things. So three different distinct prayers, distinct circumstances, everything. And there are several by law, case laws on those three aspects.
So we need not bother ourselves with that. Why? Because certain facts are admitted.
Certain facts to what extent? My lord,
Correct. So that's why I asked you. Fact that
I am coming.
the predecessor of the petitioners were in service in regular post is admitted. They had died in course of employment, admitted. Petitioners applied for employment under died in harness category, admitted. Petitioners were appointed under died in harness category. How will you appoint?
I am coming. I am coming.
There cannot be any vacuum, Mr. Sen.
Kindly come.
No, whatever, you have appointed them under dining category casual, very well.
Not under dining harness category, not at all. Kindly come to page number 50.
Yes, come to that.
Page number 49. 49.
Very well, 49, as you say.
49. Subject is prayer for employment on compulsory ground.
Correct.
They were requested to appear on such and such date. Were also requested to produce necessary certificate testimonials.
So what was he considering?
I am considering his application.
So without publishing, without inviting application, without inviting application from general people, all and sundry, he will just take a person of his choice.
Lord,
he could not have done that.
My lord, these applications were made.
So it is clear from this He was considering a compassionate appointment application.
Now, Lordship,
Absolutely clear.
Lordship, kindly have a look, page number.
But what you have given is different. Very well, I accept it.
Page number 107, they
Yeah.
have accepted it, page number 107.
Yes, yes.
Page number 107.
This you argue. They have accepted it.
The interview held on such and such date, following candidates are hereby appointed as conductor on contractual basis 1 year from the date of their joining on following terms and conditions. No whisper, no mentioning, nothing regarding that this appointment is on compulsory term. Nothing. To apply, then there were much more applications. So oral interview naturally, and then this appointment letters were followed.
So, are you trying to suggest today that North Bengal State Transport Corporation, or yes, has proceeded to employ individuals by pick and choose method, by a backdoor entry?
Maybe.
No, not maybe. You have to, you are a state. You have to take a firm stand.
Madam, may I get? Not against sanction post.
And that is all right. I'll accept your contention. Not against sanction post. Fair enough. Fair enough. I will accept all your contention on that. But you see why I am putting this to you? Because a question is arising here.
My affidavit
Yes.
has been made to you that it was a situation basis. There were applications and just by law as a situation basis.
Correct. I am tend to accept your contention on that. I tend to accept your contention, but I am unable to accept your contention. Prima facie though, that a corporation will simply sit on the basis of a letter issued by an individual accept their employment without publication, without inviting others by way of a backdoor. It is very difficult to accept that. But what was offered to them is contractual. There is no denying the fact.
It does not appear from the records that public in general or my lord in a mass scale
Was invited. Absolutely. You can't improve that. Absolutely. I get you. So this really boils down to,
What's of the deceased employees, they applied
and we got.
their applications clubbed together and it was taken up for consideration. This is the fact.
Correct. So right, wrong, indifferent, they were allowed to work contractually and they accepted that.
And they
That you
accepted
can say.
And it is being continued for years.
Yes, that you can. So therefore, the application is practically for regularization.
Now, my lord, may I just go across certain paragraph of my affidavit?
Hmm.
There are three, my lord, pleadings on our behalf. My lord, one comprehensive affidavit, one affidavit implied to the petitioner supplementary affidavit, and again, my lord, another affidavit, rejoinder. Now, may I?
Yes, rejoinder is filed by you.
Yes, one did, but one after another, they filed application. We also took exception to that. Now, Lord, kindly come to first that comprehensive affidavit. It was, my lord, affirmed.
I have it. I've read it. Yes, come back once again. Yes.
Affidavit.
Yes, yes.
Now, Lord, kindly come to page number 4. আপনি কি বসুন দয়া করে। Page number 4, subparagraph D. Have you spotted, my lord? Now, may I read just, my lord, 2 sentences that, yes, from the below. I state that. Have you got it, my lord? I state that those engagements, including those of the writ petitioners, were neither against any sanctioned vacant post nor the prescribed procedure to fill up a vacant sanctioned post in the state transport undertaking, including the respondent corporation followed. So far as the so far as the selection of the petitioners for such contractual engagements was concerned, I submit that at the relevant time, since the total applicants applied for appointment upon death of their respective fathers to the same corporation outnumbered the capacity of the corporation, even for those contractual engagements. Certain modality was adopted by the corporation for such selection as elimination process. I state that such procedure for selection of persons for the post of conductor on contractual basis was solely a situation-based administrative decision of the corporation without having prior or post sanction of the state government. I submit that such engagements of the petitioners by the respondent corporation cannot be construed as any appointment on compassionate grounds, since neither there was nor still there is any comprehensive scheme for appointment on compassionate ground in any of the state transport undertakings, including the respondent corporation. However, during pendency of above the petition and other analogous matters, deliberations in detail have been held between Finance Department and the Transport Department of the State of West Bengal with regard to an issue as to the possibility of formulating a scheme for compassionate appointment in the state transport undertaking, including the respondent corporation, and considering all the aspects in the matter as narrated below. Such deliberations have led to a conclusion that, very important, it is not possible for the respondent state government either to formulate a policy for compassionate appointment or employees to offer compassionate appointment in the state transport undertakings, including respondent corporation, or to absorb in such existing contractual worker as regular employee who are serving in the corporation.
That is your consequential defense. But for that, you have to first establish the word that you have coined, situation based. Now, I find from your affidavit, paragraph 8, that this has been affirmed as an information derived from the record. What record do you have to support this is situation based?
So whatever, my lord, the NBSTC, my lord,
Now, where is that record? This is information based on record.
that can be placed by NBSTC. Because we on the basis of the
No.
information gathered
This
from-
is information based on record affirmed by not NBSTC, affirmed by Alapon Bandyopadhyay. So therefore, Alapon Bandyopadhyay must have seen certain records for him to make an averment on oath before this court. What is that record? That it is situation, very interesting word, situation based.
that can be used by the NBSTC.
No, that you have to produce. Then I will discuss. Then I will not place reliance on this statement of yours. If you are unable to produce this record, situation based is a very wonderful coinage used. I must say, I could not follow what is the meaning of the word situation based. Situation based means maybe that I require 25 persons today. Situation requires I employ 25 persons. What is the situation? Morality to appoint, that is situation based.
In a sympathetically manner, very secondly consider.
Sympathy.
Yes,
So you have been guided by sympathy.
sympathetically, because yes, they are the words of the deceased employee, very good for the time being. Let something be done for them. Instead of nothing, let something be done. I
At the cost of the state exchequer in this fashion.
feel that happy. Malad,
No,
I am
no.
very malad,
Very difficult
I
to say.
say that at least
This is troubling me. Administrative decision of the corporation. Situation based administrative decision. Record has to be there to support this. And that will explain whether this is a compassionate appointment or an ordinary appointment.
compassionate appointment there cannot be, because my lord, he said now.
It is an administrative decision. So, sir, ordinarily, sir, to my understanding, note sheet is prepared, sir. Ordinarily. Little that I had experience in going through the files.
not
Note sheet is prepared, countersigned by each officers of the rank and finally by the senior most officer. Each one vets it.
Let them produce.
No,
the
you
record.
have to produce it. You have gone through the record.
Very good, I shall put it, but Malad, kindly consider one thing. That even if there is any note sheet, kindly
Okay, let's
consider-
go further from this.
Please see,
Let us accept that you cannot support this and proceed as it is. Let us proceed.
Now, my lord, now. my
You
lord,
lose one defense does not mean you lose the entire thing. There are other factors which do we
now,
can consider.
next, my lord, this is, my lord, the main, my lord, the contention, main contention in that, my lord, the affidavit,
Yes, nothing more is here.
nothing. This,
You must be relying on Uma Devi.
I'm coming, Lordship. Judgment letter of Lordship. Kindly, my lord, let me
What
know.
more is there?
There are two other documents, there are two other, my lord, let me, Lordship, kindly.
Yes.
Now, my lord, kindly, my lord, happy to add, my lord, affidavit in reply, my lord, the filed and or about on behalf of.
I do not consider their case on this. That whether you had a scheme, whether 500 persons were taken after this or not, even ignoring that.
Affidavit reply,
Yes.
we have annexed one, my lord.
You have annexed.
I have annexed a notification. Notification of 3rd December.
Reply is filed by them.
This is a reply to their supplementary affidavit.
I see.
This is a reply to their supplementary affidavit. Reply.
Oh, I see. I have got that notification. Yes, yes.
6.
That is 2007.
2010, but after that 2009. So kindly have a look.
Yes, yes, yes.
2009 notification, my lord, they, my lord, relied upon, my lord, the Labor Department notification of 2002, and their contention in that supplementary affidavit that it is a Labor Department notification that is, my lord, applicable to the undertaking also. But in 2009 Labor Department notification, it appears that whereas the kindly come to the 2013 notification. Labor Department notification 2013 at page number 12.
Yes.
What is, my lord? The 251 EMP. The governor is pleased hereby to make the following scheme regulating the appointment on compassionate ground in supersession of all previous orders in this respect. First of all other order gone.
How
Now-
is this scheme applicable to this case? Why will I read this?
Very good.
First tell me that. Then you come to the scheme.
They relied upon. I said no, there is no scheme. This scheme is for only this scheme called the
No, they by this time they were already appointed.
the government.
By this time they were already appointed. So new scheme cannot regulate their appointments.
So at that point of
Mr.
time,
Bhattacharya may have said so many things, but the fact remains
Right.
that you took an administrative decision to appoint them. Question is whether under compassion appointment or ordinary appointment. Ordinary appointment you could not have made. It is a compassionate appointment.
does not appear at all that it was a compassionate appointment.
Very well.
They applied for. They applied for. But this, my lord, the eventual offer made to them, my lord, for that engagement, temporary engagement, now, my lord,
Yes.
now, my lord, in these pending matters, we have taken another point that in this pending matters, in these proceedings, time to time, several orders passed in 2000, in 16th March 2016, my lord, an order was passed by the division bench, where state has gone to the division bench against an order of 7th August 2014. An interim order was passed in these proceedings on 7th August 2014, whereby the state was directed, that the transport authority was directed to formulate a scheme for regularization of the petitioner as an interim measure. This direction was given. It appears from page number 3 of this order. Now, my lord, appeal was preferred against that. That's the appeal was preferred against that interim order. Now, my lord, the appeal court say, not yes, and my lord, since my lord, contempt, sorry, my lord, I'm very sorry, my lord, contempt was preferred. CPA, contempt was preferred. Sorry. Now, my lord, kindly have a look.
You prefer an appeal from the contempt? No, I want to understand. Certain areas of the legal employees are concerned. These orders are challenged. Yes. No, this will, how will this help?
Stay, yes, in the appeal, stay application. While hearing the stay application, page number 3.
Yes, yes.
While hearing the stay application filed in connection with the aforesaid appeal, initial stay filed and been partition. An honorable division bench of this court comprised of one of the honorable justice, such as passed a common interim order. We therefore direct the transport secretary to formulate a scheme for regularization of the petitioners against the existing vacant post, if necessary in a phased manner, specifically against the post available out of date or retirement of the existing employees. Such consideration should be made by the Principal Secretary, Transport Department within a period of 2 weeks. Alleging willful and deliberate violation of the order dated 7th August 2014, petitioners presented contempt application. During the pendency of the contempt application, the Principal Secretary, Transport Department framed a draft scheme for appointment on compulsory ground of dependent family members of employees of the corporation who had died in harness or had retired from service prematurely due to incapacity to work. Mr. Sahara is learned advocate for the applicant petitioner's content that the draft scheme ought to be made final. Mr. Mojumdar, learned advocate, government leader appearing for the state, contended that it was not considered feasible by the government to accept the draft scheme, and accordingly applications have been filed seeking modification of the order dated 7th August 2014 before the division bench, being can number such and such. Then can all those applications for modifications are treated as on this list. So modification treated as on this list. We have heard current advocate for the party. The point for consideration in both the application is common whether the Dallas was justified in interim relief. Having regard to the limited scope of the appeal and the submission of Mr. Mujumdar, that service of the applicant petitioner shall not be disturbed until the petitions are disposed of finally, clear of the considered view that all issues must be allowed to be raised by the parties in the pending
So it's all open. So it's all open before this court. Today, the court will consider two aspects. One aspect is whether the appointment that was made was on the basis of an application for compassionate appointment. If that was so, what should be the consequence of retaining them in regular employment? On contractual basis. The second aspect the court will be required to consider is your contention whether, notwithstanding they applying for compassionate appointment against a sanctioned post held by their predecessor, whether their appointments were not attached to any particular post, and whether they do not have any right to seek the benefits of an ordinary employee. That is all. These are the two issues. Now, if you can demonstrate and show, no, I have just appointed them. They are backdoor entry persons. They are no one. They should be thrown out in that case, which you have not.
First answer would be
Yes.
that if, my lord, vacant post, the post, my lord, the vacancy arises out of death of their father.
Yes.
First of all, whether that means that ipso facto means that the said post is occupied by the what? Upon death. Thus, it is occupied by me. I am to entitle it, because even in case of a scheme for compassionate appointment, whatever it remains in the scheme that will follow.
Can.
Not that very particular post you cannot demand. This is, my lord, surprising enough so far this drafting is concerned. Can you consider? Then my father died, so I am entitled to. That post is like.
Sanctioned post. Question is whether a sanctioned post is there. Maybe in category, different category. But the post remains.
No,
Not
very
that
recent
particular
agency
post.
of Honorable
Yes.
Supreme Court very recently, my lord, this is not with me right now. That under the compassionate appointment or appointment on the compassionate ground, if it is made, then that appointment, my lord, to the ward of a deceased employee cannot be given. So kindly consider to a post.
Where he was working, certainly cannot be given. That there is no question on that. But the question is today you come up and say,
Not take it granted.
no, he was a conductor. Please understand, he was a class 4 staff. His parent was a or
Suppose cashier.
no, not suppose that. We have to take whatever it is here. So let all whatever we find from this, all were class 4 staff. Do you have anything below that? In NBSTC, anything below class 4? So class 4 staff, everyone is class 4. He is also class 4. A class 4 reserved for his parent goes to him. He does not get a better post. Because he is, in this case, you see, that those judgments are in different aspects.
First of all, this is
A person who is a officer, or not an officer, is a higher division
first
clerk.
of all, there cannot be any such claim to any post that my father used to serve
Sir,
there.
they did not raise that claim. Sir, you are saying
Even
that
if there is any compassionate scheme, here there is no such scheme. Does you kindly consider? As because, my lord, that offer was made to them to serve temporarily. What
why will you make an offer?
Yes,
Why will you make an offer?
but that is a different thing.
No,
They-
that is the mind. That is the
Madam,
most
may I
important
tell
thing.
In our country, not in this state, in our country, my lord, whatever the workforce right now, more than 50% are casual or contractual in every, my lord.
Sir, I am not
organization or
concerned with the
institution.
entire state, sir.
Kindly-
I
so-
cannot decide that.
Court never said, also kindly consider that why did you then offer? So now have to be regularized. Regularized, my lord, there are several judgments. If you also allow me to, my lord, place that. Several judgments that regularize only if it is made or done against the sanction post.
Hmm.
So kindly consider.
No, not the question of several judgments. You rely on Uma Devi. Show me Uma Devi. Show me
After
you.
that, several judgments.
After that, Uma Devi is the parent judgment. Even after Uma Devi, everyone, Uma Devi's footings has not been dislodged. On the contrary, it has been subsequently explained to what extent Uma Devi will apply. And admittedly, these are not backdoor entries. You do not accept them to be backdoor entries. You accept these are entries. Anyway,
No, as because simply, Lordship, kindly consider, since, my lord, the number of applicants are much more than we needed at that point of time because of that. So, my lord, is simple, my lord.
nobody asked you to appoint them. If you did not require a person, why did you appoint them? You have to produce that. You have used a word situation based. You have to produce that administrative decision of yours.
Kindly consider one thing, that, my lord, then, my lord, in all cases, wherever the court, my lord, was invited to look into this aspect or issue with regard to regularization. My lord, the foundation of the case of the petitioners always that we were given, my lord, the offer regarding this engagement on these terms as a casual contractual. At one point of time,
That is sad to say.
so every,
because-
every regularization matter, their basis or foundation must be through a letter of engagement contractual. But that does not mean the Supreme Court said that in all cases, whenever an appointment is given on a contractual basis, or casual or contractual, then after
Sir,
some time,
each facts are different.
even Supreme Court
Each
said-
facts are different. Each fact. Yes.
Supreme Court said 10 years or 20 years, the period, no factor.
Sir, show me the judgment, sir. Show me the Uma Devi judgment if you wish to rely. Show me which paragraph you wish to rely. I will consider it.
I want to rely, yes, I want to rely.
List of judgments if you want. Hand over the list of judgments, whichever judgment you wish to rely.
List of judgment,
Yes.
but Here and now, my lord, I can show your lordship the judgment.
No, that make up your mind, whatever. Mr. Bhattacharya will,
No, I
I'll not
shall make
permit
the
Mr. Bhattacharya to delay any additional judgment.
copies of those judgments are with me right now.
No, no, you give me the citation, then the matter ends. You give me the citation and then place it.
My lord, the 2007 column 2 SCC. My lord, 2007 column 2 SCC, page 481.
Yes. Next, name of the case. Okay, very well. Next case, next case.
7 column 2 SCC, lordship.
481. Next case.
And next lordship 2019 14 SCC 646.
Yes.
Well, so far that 2007 column SCC 481,
Which paragraph?
paragraph 14 and 15.
Next one.
And next one is 2019 column 14 SCC page 646, paragraph 13.
And the other judgment.
Other 2027 SCC page 617. Paragraph
2020.
Yes, 2027 SCC. Page 617. Paragraph 13, 14, 17, 18, and 19. But these are all on that point that compassionate appointment can be made.
Paragraphs.
Paragraph 13,
13.
14,
Yes.
17, 18, and 19. But these judgments are, my lord, I am banking upon, or my lord, bail me out from this position.
No, no. Naturally, sir, you are there, sir. I am sure.
For the,
Sir,
for the contention that when there is no scheme for compassionate appointment, so the order can be passed on the basis of prayer for compassionate appointment.
very well.
I shall hand over all those judgments, my lord. And my lord, they so far
No order for compassionate appointment can be passed. Order directing compassionate appointment can be passed.
yes.
Anything else?
Like this. My lord, this is on the aspect of that, my lord, the compassionate appointment. Now, my lord, the another, my lord, the alternative argument was there that regarding regularization. That whatever the circumstances be there, they were, my lord, the appointed, or they were, my lord, the giving the offer to appoint their engagement. Now they are serving till now. So regularization according to them. Now, so for regularization, my lord, my lord, I am relying upon 2011. These all might not be considered that one. 2011 column 2 SCC, page 429.
Yes. And
Here, Mother regarding appointment in Mother Jammu Kashmir High Court. Paragraph 12.
yes. And
Then, Mother, the on judgment, Mother delivered by our division bench. Mother, it has been reported, Mother, that Mother, I cannot recall it, either CNC or Sridhar. I appeared.
you hand over on the next day. Just
Delivered by division bench. Mother, no, copy is with me.
hand over that copy.
Copy, yes. Mother, this is my lord CSTC versus Bimal Chandra Lord. Here, my lord, may I just, my lord, pause it for a moment, lordship.
No, no. Today I can't give you time. Another matter is there. They are waiting.
My lord,
Hmm.
against this division bench judgment, because the single judge allowed the writ petition directing to regularize, and the division bench was the same. Matter went up to the Supreme Court, and the Supreme Court said there is nothing to interfere.
In that case, also you had given them appointment, like this case. No,
Not mention that.
no. In that case, also you had allowed appointment to them.
Yes.
In that case, also
Yes.
very well.
Appointment was given. Appointment or engagement was given. Only difference is that in their application for engagement, there was no mentioning compassionate.
Correct. So that makes the difference. Correct. Next. This is on regularization. I suppose. Correct. Naturally has to be.
Why I am relying on this judgment?
I will hear you, sir. There are other matter. Only one, the third one.
May
I am not concluding today.
No, may I hand over this on the next
No,
day?
these are the whatever you mentioned today, I will permit you to hand over. No additional judgments.
Immediately.
Yes.
Junior, আমি কি বললাম?
Very well. Let us proceed on this premise that these are the judgments.
These are the judgments.
Very well.
These are the judgments. আপনি পারেন।
Heard the learned advocates appearing for the respective parties. List this matter for further consideration under the same heading on. Bolo.
Next Friday,
Time
मतलब 2 p.m.
Wait, sir. You have only one matter. There are no other matters.
Sorry.
পড়তে ওইটা তো আছে সকালবেলায়। আরে না এতগুলো একসঙ্গে হলে হবে না, পরে পড়তে জুলাই হবে না, তার আগে 4 জুলাই তার আগে দেখে দাও, তাহলে 4th এর আগেরটা এটাকে শেষ করে দিলে ভালো হয়। Can you bring the records on the next date?
Not next week. It's a fortnight time. That
4th July.
कुछ भी
4th July.
At 2 p.m. my lord, kindly कर 2 p.m. my lord, kindly my lord,
2 p.m.
much obliged.
मतलब पाठ
Assign
I have to conclude it. Wherever I go, it will go with me. So I have to, in my interest, I have to conclude this. Enough.
But separate order be passed in other matters. 6 matters are
Only one order will be passed. Only one. All. Yes. Dako, পরেরটা দেখো। 2:45 ডাকো। Give you all the names, appearance of the parties, it will come. I will decide, if at all, by a common order. And Mr. Sen is leading the matter, so you also have the advantage, the court also has the advantage. Give your appearance with the number of the petition, and Mr. Sen is common in all. So, yes, call the list.
Item number 1169.
Unless I fix it at the first matter, this situation will not improve. You see,
Okay, then take it on at 10:30.
at 2 I'll take it up. দাও। এটা পরের দিন নেবো 2 থেকে। You continue, start, sir.
No, 5 minutes. NGMC, Millard, NGMC, Millard.
In this matter, my lord, Mr. Senior Advocate, Mr. Joyantha Kumar Mitra is
Louder, sir, louder.
Mr. Joyantha Mitra is appointed in this matter for the respondent. So, my lord, I'll be only praying
Mr.
for.
Joyantha Kumar Mitchell, honored senior advocate, has been
He has
appointed
been
by the
appointed.
NGMC.
So, my lord, he has been newly appointed. My lord, he has received the brief. Well, he has, my lord, not gone for a conference also. My lord, I'll be only praying for 1 week or, my lord, 10 days time. my lord.
2019 সাল থেকে
Yes, my lord. He has been
I
appointed.
will not, it is entirely up to you and your learned friend. I will not make any comments.
Millard, all the petitioners before your lordship, Millard, they are in their evening of their life. 100 people have died. Even
I
then,
will
Millard, I
take
do
up,
not
I
want
will decide the
for
matter.
which, no, Millard, your lordship is enough, Millard, has given
But
Millard enough indulgence.
Mr. You see, sir, I have to decide the matter. I cannot do
That is why
magic.
they made a fervent prayer to my lord, Millard, that kindly takes it up any day, Millard, on and from 10:30. If the business of this, otherwise, Millard, we cannot complete it.
You see, Mondays, Wednesdays, and Thursdays, there is group 4 matters. On Tuesday, group 5 matter. And on Thursday in the morning, there is an original site. So Friday is the day which is there for
Friday 10:30
miscellaneous
kind of
matters. When in the morning, there are generally other matters. One matter I am hearing of Mr. Chakraborty, that will be over on that date. I presume so. That will be over on, কবে রেখেছি ওটা? 4th. That will be on, after 4th, I might fix it. 4th, up to 4th, that is no chance. At 12, I might fix it. I might take it up to 12:15. I'll take it
11.
up to 1.
11,
12:15. I'll take it up to 1. Or 12:45 to 1:30. 12:45 to 1:30.
4th,
Or no, 4th is fixed already. Next week.
26,
Yes, yes.
26, 26 কর না 26 জুনে এক সপ্তাহ তো হলো
No. He will 1 week. No, not on 26th. I'll give you
27, 27 শনিবার 27 শুক্রবার
11th তো হবে না না ওটা 11th সকালবেলায় 11th দুটোর সময় তো নেই ফাঁকা আছে তো
সকালবেলা
2 PM আছে থাক 11 12:45
12:45 11 জুলাই বাই চান্স
1:30 it will continue 1:30 I'll do it I'll hear out because on that date you conclude your matter whichever way and Mr. Mitro I'll give him one more date after thereafter yes so these assigned matters will never be concluded in 3:30 this time because that matter will continue for Mr. Sen. You see now the situation is that matter has started. So Mr. Sen will hear place his arguments and thereafter I'll hear Mr. Naik if necessary and I'll conclude it. So on the next date, unless it is in the morning, you will not get a chance.
but morning will before 12:30 not possible
No, because there are other matters, Mr. Bose, because 12:40, 12:45 come, 12:40, 45, I'll take it up. 45.
July, your lordship is fixed.
Yes, on that is the best. Do it. I'll hear you. Up to quarter, if you want, up to 1:45, I'll hear you.
Very good.
That time there is no 3:30 in the morning. So you can always come up. Unless, of course, you never know. That is always. হ্যাঁ এটাকে দিয়ে দাও এটাকে অর্ডার দেওয়ার দরকার নেই এটাকে দিয়ে দাও 11 oh list this matter in the monthly list of July marked 11th at 12:45
Lord, I tell your lordship 12th July is the date when the inauguration of circuit bench maybe my lord your lordship
on 12th court we will not leave your apprehension of your junior is unfounded you will be here on 11th we will be here
He may not be there exactly.
no
12th it is on 12th not 11th so 11th we will be here
May I have your
yes madam
side matter, your lordship? It's an assigned matter, your lordship.
acha call the original side now আজকে তো
the earnest money of 5 crores 88 lakhs, Your Lordship. We are filing an application that the same may be kept in the short-term interest-bearing account, Your Lordship. My impediment in filing, this has been affirmed, stamp punched, everything, but because we are not part of the proceedings and this company was wound up in 2008, Your Lordship, we do not have the full cause title. Whatever cause title we had, we have earlier also we had made file. Your Lordship, I am not party to the proceedings. I have filed with a cause title. This is my judge's summon with a cause title that I have. I am filing, Your Lordship. If Your Lordship could grant me leave, because I'm not party to the proceedings, so I'm not able to. Your Lordship, I had participated in the auction. No other in. But my money is lying for 1 year without any interest-bearing account. Your Lordship. Your Lordship. I'll do the deed, Your Lordship. Your Lordship, I'll take inspection. I'll take inspection. Your Lordship. Your Lordship. I'll take the inspection today and I'll file it. Obliged.
Every Friday we are here, but everybody 3:30. Unfortunately, only on 4th Friday. Any day, my lord. Take some time. I can.
Not any day, since this has been going for a long, well, not any day apart from Friday, Your Lordship.
Anyway, we are here. We start. What if 3:30?
My lord, kindly takes this matter
But only
any
on
date,
4th I have
Lord.
to get an answer.
Or my lord, on Friday, my lord.
Only 4th Friday.
My lord, on Friday, my lord, if it can be fixed at 3, my lord, then also. My lordship, 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 lordship. Lordship.